Hey guys, let's take a look at this motion for leave to file, motion for new trial that Alex Murdaugh's attorneys have filed, and motion to suspend the appeal because they said it was going to be a bombshell, and this time I believe they were not exaggerating. Oh boy, I just have skimmed this, but wow. Let's get into it. This isn't really about is he innocent or not innocent. Maybe they'll have something else about that, but this is about the process of the trial, and the allegations really are extremely serious, and they have some receipts. So here they are asking to suspend their appeal and move for leave to file a motion for new trial based on after discovered evidence in the Court of General Sessions to suspend this appeal during the pendency of the motion. And they attach the motion, which is where things get pretty exciting. Now, remember, before I get into this, because I'm going to basically read what they have to say, these are their contentions, and this is the evidence they've gathered to support them. We don't have any rebuttal by the clerk of court who's implicated in this, the court, the state, or whatever. They may have a different side to this, of course, but still, what we can do now is at least look at what is Murdaugh putting up here. It's not a tiny ninja thing. This is something far clearer than that. All right, so here he comes through his counsel and says that he should get a new trial because they have discovered the clerk of court tampered with the jury by advising them to not believe Murdaugh's testimony and other evidence presented by the defense, pressured them to reach a guilty verdict quickly, and misrepresented critical and material information to the trial judge to remove a juror she believed to be favorable to the defense. So they're saying the clerk of court, Rebecca Hill, instructed jurors to not be misled by evidence presented in Mr. Murdaugh's defense. Now, you don't have to be an experienced trial attorney to know the clerk of court shouldn't be saying things like that to anybody on the jury, right? If this happened. She told jurors not to be fooled by Mr. Murdaugh's testimony in his own defense. She had frequent private conversations with the jury foreperson, a court-appointed substitution for the foreperson the jury elected for itself at the request of Ms. Hill. During the trial, allegedly, she asked jurors for their opinions about Murdaugh's guilt or innocence. No. They say she invented a story about a Facebook post to remove a juror she believed might not vote guilty. She pressured the jurors to reach a quick verdict, telling them from the outset of their deliberations it shouldn't take them long. She did these things to secure for herself a book deal and media appearances that would not happen in the event of a mistrial. So they threw in some motive into this and betrayed her oath of office for money and fame. Now, whether Murdaugh did the crime, as I currently believe, and many people do, but many people don't, he's owed a fair trial, right? And that's what his attorneys are hitting at here. And I think whether you think he did it or didn't do it, you should believe he's owed a fair trial. So if this stuff is true, his attorneys have dropped a major bomb in this case, the biggest bomb so far. Once these facts are proven, the law does not allow the court any discretion about how to respond. It must grant a new trial. So here we go with their statement of facts. Again, this is their side of it, but we will see they do have some evidence for this. Murdaugh was indicted. We know that. We know his trial ran. And we know how that resulted. So they're saying after returning from President's Day, February 20th, Ms. Hill, the clerk, began to enter the jury rooms often. And they have an affidavit of a juror that you'll see in a little bit that supports that. As the defense began its case, she allegedly told jurors, "Y'all are going to hear things that will throw you all off. Don't let this distract you or mislead you." No, that's bad. And this is supported allegedly by another juror on the case. Additionally, Ms. Hill and juror number 826, the new jury foreperson, on multiple occasions went to a separate room to have private conversations lasting 5 to 10 minutes. Sometimes they would go to the bathroom together, and the foreperson never said anything about what they talked about. Okay, well, that's a little mysterious and bad, but some of this stuff is not mysterious. They go ahead and put out there what they say is wrong, like just some of the things I've already said. This gets more explicit as we go. The clerk even instructed jurors they could not ask the foreperson about the conversations. Okay, so Murdaugh, as you remember, testified in his own defense. And Ms. Hill, the clerk, told jurors not to be fooled by the evidence Murdaugh's attorneys presented, with which at least one juror understood to mean that Murdaugh would lie when he testified. I mean, that is the logical implication of that, right? She also told jurors to watch him closely and look at his actions and look at his movements. And one juror understood that to mean that Mr. Murdaugh was guilty. Immediately after Murdaugh testified, the foreperson told the jury that Murdaugh was crying on cue. Okay, that's discussing the case. She also criticized the former foreperson, juror number 589, for handing Murdaugh a box of tissues, because that's what the defense wants us to do. The next court day after Murdaugh's testimony, the clerk told the judge about a Facebook post she purportedly saw on the evening of February 24th, the day Murdaugh's testimony concluded. And this allegedly was from Tim Stone, which is the ex-husband of a juror, stating his wife was saying she was on the jury and saying stuff about her verdict was going to be. And what you're going to hear in the evidence later on is he says, no, I never said that. And also the wife said, no, I didn't say that. Judge Newman asked her to produce a copy of the posting. She could not produce a copy. But according to her, a subordinate employee in the clerk's office, Lori Weiss, discovered that the post was taken down and replaced with an apology post. And this is coming out of a book that was written, Behind the Doors of Justice. This is all really bad. All right. The apology post states the initial post was already deleted, so on February 16th, so it would have been impossible for her to see the original post on February 24th. Okay. So the ex-husband says in a sworn statement, I didn't say that stuff. That I didn't even have a Facebook page named that, you'll see. And Murdaugh has obtained an authentic download of the entirety of his Facebook activity through this relevant period. I didn't know you could do that, but whatever. And then he, in fact, never posted anything to this word-of-mouth Facebook page. The person who made the apology post is an unrelated person named Tim Stone and is not the ex-husband. Now, the clerk talked to the juror about it, alone in her office in the courthouse. Okay. She told the juror that someone had emailed her stating that her ex-husband had been drinking. She'd been drinking with her ex-husband, and while drunk, she gave opinions on the guilt or innocence of Murdaugh. The juror said, I never did that. I haven't seen my ex-husband in 10 years. That's in her affidavit. She said, let me see this post. But the clerk wouldn't show it to her. And then the clerk allegedly said, tell me whether you're inclined to vote guilty or not guilty. And the juror said, I haven't made up my mind yet. So then the clerk later told this juror that law enforcement went to his house and confirmed he made the post. But this is a fabrication by the clerk. Ms. Hill told the juror she would somehow reinstate a restraining order that the juror had previously brought against Mr. Stone, but she didn't have the authority to do that. I mean, what is going on here? Still, later that day, the judge examined the juror regarding the non-existent Facebook post and the email in camera. The juror described her interactions with Ms. Hill regarding a Facebook post. She denied making any inappropriate comments about the case to third parties and stated she wanted to hear closing arguments before forming an opinion on guilt or innocence. That's what you should say as a juror. After she was dismissed, Judge Newman said, oh boy, I'm not too pleased about the clerk interrogating a juror as opposed to coming to me and bringing it to me. Yeah. The next day, on March 1st, 2023, the jury visited Moselle, the site of the murders. During the visit, the foreperson and the clerk walked off to have another private conversation. In her book, the clerk more vaguely hints at communicating her opinion on Murdaugh's guilt to the jury during the visit to the Moselle property. While the jurors visited the Moselle property, the clerk says, we could all hear and see Alex's story was impossible. Some of us, either from the courthouse, law enforcement, or jury at Moselle, had an epiphany and shared our thoughts with our eyes. Should the clerk be writing this in a book or doing it in the first place? That's a no. At that moment, many of us standing there knew, and they knew that he was guilty. That day, Judge Newman, who I like, held an in-camera conference regarding the tenant coworker email in which he decided to revisit the post. Okay. The clerk said, yes, I think it was Friday evening. Just for a brief moment, I perused this and saw it. She basically just glanced at it. And that was enough for her. She couldn't keep looking at it. And then when the email came in, she figured this was all going together. We couldn't find it later, though, when you told me to. And then we found out his name. And the court said, yeah, they got drunk or whatever. Harpootlian's chiming in. Yeah. So there's nothing really there showing that the ex-wife really did anything. Of course, she denies it. So does the husband, the ex-husband. Ms. Hill never saw any such Facebook post. The attorneys say she made it up. Further, she knew the apology post was not posted by the ex-husband. The next day, the day of the verdict, juror 785 received a call from her ex-husband that she did not answer. The call upset her because Ms. Hill's lies had led her to believe he was posting on Facebook about her and might be stalking her. She asked to speak to the clerk. She told Ms. Hill that she was scared. Ms. Hill told her that the Murdaughs probably got to him, meaning the ex-husband. Ms. Hill once again asked her opinion regarding Murdaugh's guilt. No. The juror told her that Creighton Water's closing was good, but she still had questions. It was good, by the way. Ms. Hill asked what the questions she had, and the juror said that she was concerned that no murder weapon was found. A fair concern. Ms. Hill then asked, well, what makes you think he's guilty? The juror said to Paul's video at the dog kennels, and that's, of course, an important piece of evidence, too. Should they be discussing this? No. Ms. Hill then told the juror that everything Mr. Murdaugh has said has been lies, and I should forget about the guns. They'll never be seen again. If that happened, I don't think I have to tell you the ramifications of that. Ms. Hill, because she's the clerk, then asked the juror about the views of the rest of the jury, telling her that if the foreperson would just go in and ask for a raise in hands, this would be over and done with, and everybody needs to be on the same page. She went to the jury room. 10 minutes later, she was excused from the jury. In open court immediately after her excusal, she asked the judge if he had spoken with the clerk of court, referring to the conversation that morning. Judge said, I haven't spoken with her today, and this is totally independent of any conversation regarding your ex-husband. When the jury began deliberations that evening, Ms. Hill told him it shouldn't take long, and if you go past 11 p.m., you're going straight to the hotel. And smokers were not allowed to have a break until deliberations were complete. 6 smokers on the jury. Okay, wow. That's also crazy. But I don't blame them. I might have started smoking too if I were on the jury. Ms. Hill told jurors that after the trial, they would be famous and predicted the media would request interviews with him. This stuff is off the chart insane, but they are citing to affidavits. I mean, this is, if you're in a trial, this is not really bad. Ms. Hill even handed out reporters' business cards to jurors during the trial. So one juror went on Good Morning America the night of the verdict, which is why on the day that jury began deliberations, he wore a suit coat for the first time during the trial. Ms. Hill pressured the jury to speak as a group of reporters from a network news show. She traveled with jurors to New York City. She got a book deal. Her book, Behind the Doors of Justice, was released August 1st. All right. So a last point about Ms. Hill's efforts to promote her book show her dishonest efforts to profit from the trial continued after the verdict. A film crew negotiated a contract with the sheriff's department to use courthouse bailiffs to provide security while they filmed a documentary. While it was closed for Confederate Memorial Day. Okay, this is still South Carolina. I mean, what? Oh my God, what is happening here, people? I mean, I'm Southern law, and this is further south than I am. All right, the film crew had previously recorded an interview with Ms. Hill. On May 9th, Ms. Hill sent a memorandum to the film crew purporting to be an addendum to the contract. She wanted the film crew to pay $1,000 a day to the county to use the courthouse and made a nonsensical statement about not having authority outside South Carolina. What? Then she bizarrely added a handwritten demand. Also, in exchange for the use of the likeness of Rebecca Hill in an interview, a minimum of 5-second video and audio clips will accompany the usage on the first reference. The book cover for the book Behind the Doors of Justice will be shown, and audio will include Becky's introduction as clerk of court for the county and author of the book. The film crew ignored this, but like her jury tampering during the trial, it was an attempt to violate South Carolina Code 8-13-700A, which provides no public official, public member, or public employee may knowingly use his official office, membership, or employment to obtain an economic interest for himself. Legal standard. Do they really have to say at this point if they're right on this stuff? Yeah, they kind of do, but whatever. A defendant in a criminal prosecution is constitutionally guaranteed a fair trial by an impartial jury, and in order to fully safeguard this protection, it's required that the jury render its verdict free from outside influence. Hello, this is State versus Captain Obvious. When the defendant presents a credible allegation of communications or contact between a third party and a juror concerning the matter pending before the jury, the defendant has an entitlement to an evidentiary hearing. Evidentiary hearing. So this could ratchet up even more, people. Whew. All right. The court has long held that the remedy for allegations of juror partiality is a hearing in which the defendant has the opportunity to prove actual bias. If the defendant proves the alleged contacts occurred, the prosecution bears the burden to show they were harmless. All right. Yeah. Well, they occurred, apparently. All right. Sorry, there's something outside, so I got sidetracked for a second. The presumption is even stronger when the contact was made by a court official. That's fair. Where there was private communication of the court official to members of the jury, an occurrence which cannot be tolerated if the sanctity of the jury system is to be maintained. A new trial must be granted unless it clearly appears that the subject matter of the communication was harmless, could not have affected the verdict. Like, man, that was a bad storm last night, or it's really hot outside. Okay, you can do that, but, you should do the minimum possible. They don't need to be rude, but I think everybody understands how communications with the jurors are supposed to work. And it ain't this. Argument. Do they have to argue after they lay out these facts? And they should have an emoji that just shows a mic drop. Because if the state doesn't refute this evidence convincingly, it is what it is. A state official, the clerk of court, in this case, had extensive private communications with members of the jury during trial. This allegation is supported by sworn affidavits of jurors and a witness to juror interviews. Okay, so they have jurors submitting affidavits. You'll see it in a minute. We're getting there. This is a pretty long motion. Testimony in in-camera proceedings and other evidence in Ms. Hill's own book. So the court must hold an evidentiary hearing. All right. Whoo, this is going to get hot. If the allegations are proven at the evidentiary hearing, under binding appellate precedent, the court must grant a new trial unless it clearly appears the subject matter of the communication was harmless and could not have affected the verdict. The subject matter was the evidence being presented at trial by the defense. This was an attempt to influence the juror's verdict. It vitiated the sanctity of the jury's deliberation and Murdaugh's sacrosanct right to a fair and impartial jury. You can't feel sorry for Alec Murdaugh. I mean, he's just rotten. But what you can say is that if this happened, this is an affront to the criminal justice system generally. This cannot stand if this happened. I completely agree with the defense on this in terms of how they interpret the law. People will talk when they should not in a 6-week trial. They're not asking for perfection. Mistakes will be made. People are fallible. Lawyers combing the proceedings after the fact will always find that they made mistakes and errors. Yeah, and I kind of thought that might be what this is, right? That's what they were going to do. But boy, it's not. They concede that. If it was any little thing, verdicts couldn't stand and all that. So, if it's harmless or whatever. The issue now is not ordinary and inevitable mistakes that occur in any trial, and that is putting it mildly. And they don't usually put it mildly. Intentional misconduct by an elected state official, deliberately violating a defendant's constitutional right to a fair trial to secure financial gain for herself. And that's just icing on this terrible cake. For example, in this case, a bailiff told a jury in a murder trial that wicked fellow, he's guilty. But then the Supreme Court of Oregon held the statement did not require a new trial because it didn't prejudice the outcome. The Supreme Court reversed, said, look, the evidence developed against the defendant shall come from the witness stand in a public courtroom where there's full judicial protection of the defendant's right of confrontation, cross-examination, and counsel. Yeah. All right. In this case, they cite Judge Newman's own instructions. The verdict that you've reached is supported by the evidence, circumstantial evidence, direct evidence. All the evidence pointed to only one conclusion. That's the conclusion you all reach now. All right. It's not what they're saying here is deciding whether to grant a new trial is not whether the court believes the outcome of the trial would have been the same had she not done that. If that were the case, the court would sustain a guilty verdict even if she coerced the jury to vote guilty at gunpoint. And this is logical. What they're saying here is logical. There are some errors that are just too great. This cannot be the law. I pretty much agree with them on that. That's my opinion. They're saying if it's not harmless, the subject matter, you got to let this go. Telling the jury not to believe the defendant's defense or his testimony regards the merits of the case. Yes. I mean, they're just walking through the stuff here, and they say, we need a new trial. Okay. And here's some things they have. They have an affidavit from a juror, juror 630. Toward the end of the trial, before Murdaugh testified, the clerk of court told the jury not to be fooled by the evidence presented by Mr. Murdaugh's attorneys. And I understood that to mean he would lie when he testified. Watch him closely, look at his movements. This is a juror on the case in a sworn affidavit, saying that also that the foreperson said that he was crying on cue, and they shouldn't have handed him a tissue. And the jury frequently discussed the case during breaks before deliberations. I mean, they're not supposed to do that. It's a little more vague here, but this other stuff above it is not vague. And the private conversations, it shouldn't take long. Oh no, it's just so bad. All right, here is an affidavit of somebody about a juror. This was one. They said they were going to get the affidavit, but they couldn't. But this guy heard this, so that's not really great evidence. But they have a lot of evidence, and they're really just trying to get to an evidentiary hearing here. End of the trial. Passed out business cards from the media. And it was another person that saw her go in the bathroom. Says, this is not the only person who saw that. You're going to hear things that will throw you off. Don't let this distract or mislead you. That's similar to what the juror testified to above. And there was a juror known as Boston who was very emotional during the trial. Juror 826 began walking with the clerk of court at the scene of the crime. Sometimes the jurors are split up. All right. Let's go here. Here's a transcript from an in-camera hearing. And this is about this stupid Facebook post. I think they quoted pretty much about that in there. Here's her book, Behind the Doors of Justice, excerpts. The Murdaugh Murders is her book name. And, I haven't read this book, not really interested in it, but they quoted from it in their motion in ways to show that, and this is really to show she had a financial interest in how this was all going to work out. NBC put us in the hands of the fabulous Haley Barber, Dateline producer, who put us up in a nice Manhattan hotel, fed us at a restaurant, Avenue of the Americas. The jurors told me they felt like they were heard, loved their 15 minutes of fame at the Big Apple. We had behind the scenes happening with our jurors, the alternates and originals for Murdaugh trial. Here's somebody focused on the crowd. She says, whatever. Okay. I'm going to skip through the book. We know what the story is there. One of the roles of Clerk of Court is to be Switzerland between the jury, the lawyers, the public, and any other entities involved. But when we were riding back in a vehicle, we're just regular people. Just as the jury were doing this, come on. And this has to do with a Facebook post. I'm not going to stay on it because I'll tell you the story is, he says that was not a profile that I had. I had not been drinking with my ex-wife. I didn't say she said anything. The ex-wife who was on the jury said, I haven't seen him in years. So what is all this? And she was dropped off the jury allegedly because of this. There it is right here. I'm the ex-husband of this juror. I did not post anything to this Facebook group. I didn't post that she was talking about the case. I didn't post what's attached as Exhibit A. I don't have a Facebook page set up as Timothy Stone. I was never contacted by law enforcement about this stuff. I didn't even know she was on the jury until I heard her voice on a recording when she was being excused as a juror and she was discussing eggs. I remember that. It was all bizarre there. So he's saying I didn't even know about this until then, until after she was off the jury, which she also says. Here's an attorney from Hart Poodlian's firm. He met with Tim Stone, and he's got the Facebook stuff. So let's see what this is. Here's an affidavit of juror 785. I was the juror. The clerk told us not to be fooled by the evidence presented by Murdaugh's side. Bad. I mean, it's more than one juror, 2 or 3, right, that have said this. It's not good. Then she talked about how she was questioned on this fake Facebook post. And I'm going to move this. I got that. Yeah, sorry about that. I didn't notice it. Let me get more of this on the screen. Miss Hill said the Post said I'd been drinking with my ex-husband, and then while drunk with him, I talked about the case. That never happened, and I told her it didn't happen. I didn't go drinking with my ex-husband. I hadn't seen him in about 10 years. I asked to see the Post, but she wouldn't or couldn't show it to me. I've never seen it. And to my knowledge, no one has. So then she told me the police went there and said, well, he did it. He said he did it. But, of course, he says that never happened. All right. And she got a call on the day of the verdict. I guess that's when he found out she was being booted out or something. I don't know. He didn't answer it. And she told it to the clerk, and she said, the Murdaughs probably got to him. Not a thing you should be saying when Murdaugh's on trial. All right, so she asked me about the views of the rest of the jury, and they could get it done with pretty quick. This is just overwhelming. Well, 2 weeks later, I did talk to my ex-husband and told him how mad I was about this post. He said, I didn't do that. I didn't write any posts like that. And he genuinely seemed not to know what I was talking about. And then a couple of jurors were in a unisex bathroom together, single toilet for an extended time. They did this frequently to talk about the case that she says she thinks. And then in the van going to the courthouse, juror 864 said Special Agent David Owen lied on the stand, but then nothing would happen to him. Okay. And then the clerk and a juror walked off together to have a private conversation. And then something about, I was removed from the jury on the day of the verdict because a coworker purportedly said I expressed an opinion on Murdaugh's guilt or innocence while delivering a refrigerator to a tenant. I don't know whether that statement was made. After I was dismissed from the jury, I spoke with these people. They told me and my husband that the affidavits the prosecution drafted with their signature was not what they said to him. They told me that, so I guess somebody did swear that this juror has made some kind of statement. All right. They were held for 9 hours at the courthouse. This is just a big mess, man. What are they doing down there? Another in-camera hearing. Anybody think about Facebook? There's some discussion about the ex-husband. I work at a monkey farm. And this was completely a random stop on this. All right. Okay. I'm not too pleased about the clerk interrogating a juror as opposed to coming to me and bringing it to me. I was surprised to hear that. The court, yeah. All right. This guy says they all met with juror 326. And another juror, they say, said that the clerk said, don't let the defense mislead them. Oh, he was asked that. He did not specifically recall the statement, but he did recall the clerk commented to him and other jurors about the photos that would be admitted into evidence, indicating the images would be disturbing. Well, that's true. That's kind of benign. And they were in two different rooms. He was in a room with mostly other male jurors. He was not in the same room as some of these other jurors that have talked about it. They all talked about the case prior to deliberations, but he didn't talk to anybody outside of that. Let's see. Before deliberations began, juror 326 indicated he had minor conversations that led him to know who was a yes and who was a no. His vote changed with new evidence. And he couldn't take a smoke break. A group chat was later formed. And when asked, did you think the clerk of court was inserting herself into the process, he said, I can see this. Okay, so not as much drama in that affidavit or whatever. DreamWorks. From the clerk of court to DreamWorks. I'm looking forward to your upcoming docuseries on the Murdaugh case, and I hope you'll be able to use some of my interview. Because I'm an elected official, we'll need to modify 3 clauses in the location agreement. Okay. And then here's this thing about using her. Oh, man, this is awful. is not good. Here's what she's saying. You got to use my book cover and introduction and all this stuff. I mean, no. All right. So that's the motion for new trial that I've got, or at least all the documents that I've seen. So again, why'd they call a press conference on this? I thought, well, maybe, where if there's not a lot of fire, at least you can make a lot of smoke, but this is a lot of fire. And I think the judge is going to have to treat it extremely seriously. On the face of it, I would say this would cause his conviction, the judge to give him a new trial. Now, again, we got to hear the clerk of court side of this if they go to the evidentiary hearing, and also the state, can have some kind of helpful counter argument to this. I don't know. But looking at it, there's meat on the bone here from what they've got. This isn't pure speculation. Like sometimes you see when people want to criticize a jury verdict and even make jury tampering or jury this, that, or the other, but then it's nothing there really there. There's a there here that if I were the judge, I'd have to say, well, these people have to come in and explain this. This is a no-go. That's my opinion on this. So this is a bombshell. That's it. Thanks. Bye.